Ms. Barrett?
I have a practical question. So let's assume that I agree with you about YouTube and Facebook feeds, news feeds, but that I don't want to say that Facebook Marketplace or Gmail or DMs are not within the statute's plainly legitimate sweep. If I asked you the question, can you still win? I know that you'll say yes, but how would we write that opinion given the standard?
Well,
without having to canvass whether all of those things would be within the plainly legitimate sweep.
Honestly, I'm not sure you could reach that result without definitively holding that that stuff is within the plainly legitimate sweep of the statute. You don't have the record for that, in part because of litigation decisions that were made by the state of Florida. So I think what you would do is you would affirm the preliminary injunction, and then you would perhaps lament the fact that the record here is somewhat stunted, and then you would make clear that there might be a possibility to modify the preliminary injunction on remand. And now, at that point, I think when the lower court sort of sees all the details about how these things actually operate, they might not have the same skepticism that you're starting with. But I think there's lots of ways to write the decision that keeps the, and again, what's in place right now is a preliminary injunction for the benefit of my clients. So people that haven't sued yet, I mean, the statute in theory could apply to them. But my clients have the benefit of a preliminary injunction while this litigation goes forward. And obviously, anything this court says in its opinion that suggests what the future course of that litigation should be, is going to be powerfully, effective in terms of how this case gets litigated in the district court.